All right, everyone. Well, I'm going to start from here. We were hoping that our Historical Society president, Libby Thiersniak, would be here to open things off, but I think she must be having a little trouble finding a parking spot. So I'll step in on her behalf briefly. My name is Doria Lynch. I am the court historian, among other things, at the district court here. And we'll get started on our program in just a moment. But first, for the folks who've come in person, thanks very much for joining us. We also have about 50, 60 people on Zoom, so we welcome our virtual guests as well. The Historical Society is working on a new project to bring a learning center to the federal courthouse. This is an exciting opportunity for us to welcome more students into the building, especially once we get past this pandemic that we're all muddling our way through right now. You'll be seeing some articles coming out soon in the Indiana Lawyer about this project, so keep an eye out for those. There'll be probably 2 or 3 that come out over the course of the next year. Our goal is to open this learning center on the first floor of the courthouse around October of 2022. So please keep your eyes open for more information coming about that. Now, as they say, on with the show. I'm joined today by Mary Giorgio, who is another historian here at the court, and she's also our court's outreach coordinator. Today, we're going to delve into the lives of 2 of our 19th century jurists, Jesse Lynch Holman, who served from 1835 to 1842, and David McDonald, who served from 1864 to 1869. Our approach to this CLE is a little different, as we have 2 actors, James Hempel and Craig Reasoner, here with us to provide a dramatic reading of Judge Holman's letters and Judge McDonald's diary entries, respectively. But first, a little context. The U.S. District Court for the District of Indiana, as the court was known from its inception in 1817 until the division into northern and southern districts in 1928, was considerably different than it is today. There was only one federal judgeship in the state until 1925, and the court didn't have its own courthouse until 1861, instead occupying offices in post offices and other buildings and borrowing county and state courtrooms. The court was also much less busy than its modern counterpart. Court sessions were held in May and November each year, and the district court's criminal practice was light. Such cases usually involved theft of federal property or tax evasion, typically for failure to pay excise on whiskey. On the civil side, many cases involved property issues and debit and credit disputes. The light caseload and healthy $1,000 salary, along with the prestige of a lifetime appointment by the president, certainly made a federal judgeship appealing. The Honorable Jesse Lynch Holman was indeed very interested when the federal judgeship was vacated by the death of Indiana's first federal judge, Benjamin Park, in 1835. Born on October 24, 1784, near Danville, Kentucky, Judge Holman was admitted to the Kentucky bar on September 2, 1805, and practiced law in Newcastle, Fort William, and Frankfort, Kentucky. In 1810, he married Elizabeth Masterson, with whom he'd raised 5 surviving children. They moved to Indiana in 1811 and settled near the present site of Aurora, where Holman built Veristow, an historic home still in existence and on the National Register of Historic Places. After settling in Indiana, Holman became an active public servant. In 1811, Governor William Henry Harrison appointed Holman prosecuting attorney for Dearborn County. He became a member of the territorial legislature and was appointed presiding judge of the Second Judicial Circuit in 1814. After 2 years, he was appointed judge of the Third Circuit, and with Indiana's admission to statehood in 1816, a justice of the Indiana Supreme Court. He served on the Supreme Court until 1830, when Governor James Brown Ray declined to reappoint him. After leaving the bench, Holman returned to Veristow, continuing his law practice and increasing his involvement in the Baptist Church and the Sunday School movement. He made an unsuccessful U.S. senatorial bid, losing to John Tipton by just 1 vote in 1831. In 1834, Holman was ordained as a Baptist minister. He was a founding member of Indiana University, Franklin College, and the Indiana Historical Society. In 1835, upon the death of Judge Park, Holman began making inquiries seeking the nomination to the district bench. Fortunately for us, Judge Holman left behind a series of letters detailing his harrowing appointment process. In this first letter to U.S. Senator William Hendricks, we learn of Holman's desire to become a federal judge as he drops the name of U.S. Senator General John Tipton and Hoosier Congressman Amos Lane, Abel Pepper, John Carr, Edward Hannigan, and Jonathan McCarty.
Barstow, Indiana, July 25, 1835. Honorable William Hendricks, dear sir, the death of our respected friend, Judge Park, will necessarily direct the attention of many to the subject of his successor. Some of my friends here are anxious that I should be an applicant for that office. My health, which has been somewhat improved this season, would now justify me in undertaking the duties of the office if I could succeed in getting the appointment. I am unapprised of who will be applicants or what would be my own prospects. Among our representatives in Congress, I have some friends, but my course in great measure will be determined by the part yourself and General Tipton will take in my behalf. I shall apply to General Tipton immediately through Colonel Pepper, who has just started the Logansport, and I think through the influence of my friends he will be decidedly favorable. I am very anxious to know how the case will stand with you. You are sufficiently acquainted with me to know that no unfriendly feelings will be excited by any course you feel yourself bound to take in the matter. But I assure you, I have felt much solicitation on the subject, and if you felt it consistent with your public duties to exert your influence in my behalf, it would confer a memorable favor, and one which I should feel myself bound at all times to reciprocate in any way that lay in my power. If you and General Tipton feel disposed to aid me on this occasion, I should feel bound to depend mainly on your influence and also on your advice as to my own course in the matter. Mr. Lane seems quite solicitous in my behalf, and if elected, prepares to go to Washington immediately to personally solicit the appointment for me. I presume General Carr, General Mccarty, and Mr. Hannigan would be friendly. I have a number of influential friends who would interest themselves in my behalf, but I do not wish to apply to them unless it would avail me something in procuring the appointment. I shall anxiously await a line from you. Very respectfully, J. L. Holman.
2 months later, Holman sends a letter to his daughter, Emmarine, and her husband, Alan Hamilton, a founder of Fort Wayne, Indiana. We learn of Holman's recess appointment by President Jackson to the judicial vacancy in the District of Indiana. Article 2, Section 2, Clause 3 of the Constitution, commonly known as the Recess Appointment Clause, provides that, quote, the President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. Such appointments were not unusual in the 1800s, when the Senate was in recess for long periods of time and allowed the government to continue functioning during periods in which vacancies would otherwise have gone unfilled. For a short time, Judge Holman allows himself to enjoy the satisfaction of his appointment, but uncertainty looms.
Barstow, September 24, 1835. My dear children, I have delayed in writing in expectation of hearing from Washington the result of my application. That has terminated favorably. I, this day, received a commission as judge of the district court as long as the President had power to appoint in vacation until the close of the next session of the Senate. In obtaining this commission, I am specially indebted to Mr. Hendricks, Amos Lane, and John McCarty within the state, and to some influential friends without the state. General Tipton previously recommended another, but gave a strong secondary recommendation in my favor, and I have been informed that it was believed at Washington that both he and Hendricks wished me appointed. I feel under particular obligations to Hendricks, for had it not been for his encouragement and influence with the men out of the state who could operate directly, but with powerful heads on the Department of Washington, I should have given it up at the onset. My course was a very quiet one as to the appointment. My nearest neighbors knew nothing of it. I named it only to those who I felt was confident and could aid me. But with those I took as effective measures as lay in my power, so that if I failed, it should not have known that it was not for want of exertions. I shall be under the necessity as soon as possible to go to Indianapolis, to form some acquaintance with the state of the business in the U.S. Court preparatory for the next term. If my health will permit me to discharge the duties of the office, and the appointment should be confirmed by the Senate of the U.S., I shall hereafter feel easy in my mind as to the support of my family. My friends and neighbors, I believe, are more joyful of the occasion than my own family. Jesse L. Holman.
Just a week and a half later, in a letter to his son-in-law, Judge Holman grows more concerned that President Jackson might take the unusual step of nominating another individual to the judgeship once the Senate is back in session. Historical sources indicate that Holman was not particularly popular with Senator Harrison and much of Indiana's House delegation, but Judge Holman is not going to give up without a fight and begins to mobilize his allies.
Cincinnati, October 5th, 1835. My dear Alan, as to the confirmation of my appointment or the President's making of a different nomination, I have nothing definite to observe, nor do I know of anything specific to apprehend. The President has the power to nominate another, but such a course would be, I believe, most unprecedented. It is certain that my friends think such possibilities should be guarded against, lest a combination should be formed to defeat my success. If Tipton and McCarty stand by me, as I trust they will do, of Lane and Hendricks I have no fear. Boone and Davis have said too much to me in their letters to come forward with any material objection to my success. This, however, among ourselves. I should be glad if Kennard or any other of our delegation could be directly influenced to favor my appointment. You, perhaps, or some of your acquaintance might have some bearing upon Governor Cass or other members of the cabinet or senators of other states. I know, as I have said, of no other grounds of apprehension, but my motto is never to consider anything sure that may by any possibility be defeated, but at the same time, never to embolden opposition by acting as if I consider any real danger as existing. Every point should be carefully guarded, and for that reason I wish the earliest intelligence of any efforts that may be making to counteract my success. Affectionately, J. L. Holman.
On November 30th, 1835, Judge Holman presided over federal court for the first time. But the permanent appointment he desperately wanted remained uncertain. With his nomination hanging in the balance, Judge Holman reluctantly begins a journey to Washington, D.C. A trip from Aurora, Indiana to Washington in those times would typically take a little less than a week, depending on the weather, boat availability, and other factors. One can imagine that such a journey in mid-January would be arduous at best.
Steamboat Lady Marshall, January 19th, 1836. My dear Alan, agreeable to your suggestion and the urgent advice of Colonel Pepper and others, I am on my way to Washington City. It was very much against my inclination, but as I had resolved in my mind that this should be my last effort for office, whether successful or not, I consented to do all my friends thought was incumbent upon me, although everything seems rather against me. I was detained at Aurora for want of a boat for more than 24 hours. After I was ready to start, I was detained the greater part of today at Cincinnati by the same cause. And before this, a failure in the mails left me unapprised of what meditated at the convention at Indianapolis until the intelligence was of no avail. A letter from Tipton to Bassett, mailed December 20th, which ought to have been in Aurora the 3rd of January, was not received until the 18th, 2 days after he left Aurora for Indianapolis. It was intended to put my friends on their guard against any movements that might be made against me at the convention. Lane had previously written to me under the date of December 21st, stating that charges that 5 of our members had allied against me, writing to the President and urging him to nominate Howard, but added that I was not to fear as the nomination would be made next week. And Tipton, in his letter to Bassett, suggests a rumor or something of that nature that my name would be sent to Senate in a few days. Since December 31st, my Washington papers have entirely failed for 3 mails. This has left me entirely in the dark on the subject. Affectionately, J. L. Holman.
Difficulty of travel in the 1830s becomes regrettably apparent to Judge Holman and his traveling companion, well-known physician Horatio Gates Jameson. The 2 men find themselves laid up in a private home not far from the aptly named town of Accident, Maryland.
Evansville, Maryland Post Office, January 20th, 1836. My dear children, agreeable to the information I gave you from Portland, Ohio, I arrived here on my way to Washington City. Here on the evening before last, about 9 o'clock at night, the stage upset about halfway up the green ridge of the Allegheny Mountains. Myself and one other, Dr. Jameson of Cincinnati, late of Baltimore, were considerably injured. The doctor apparently more seriously than myself. I received a severe wound to my head, which bled very profusely, but it was not yet very painful, though I expect it will be a bad sore. But the worst injury I received was in the back of my neck between my shoulders. I am not conscious of how I received this injury. I was stunned by the blow to my head so as to be insensible of the manner of which I was injured. But suppose that my neck was strained or wrenched in some way as my head was struck, as I received no bruise on that part of my body, and am in hopes that I shall get over it before long. Myself and the doctor are with a very kind family, and the stage agents proffer us every assistance in their power. The only excuse made for upsetting was that the snow was deep and falling very fast, and had drifted so that the horses left the road, which had thrown up about there 3 feet, and drove the carriage over the bank. We were near a house, or I know not what might have been of our condition, as I was stunned by the blow, and my head was so dizzy that I was unable to stand for some time, and was supported to the house with some difficulty. And Dr. Jameson fainted before getting out of the carriage. He is unable to sit or stand or cannot turn himself in bed. I can sit rather more comfortably than I can lay, and can now write without severe pain. I have apprised Hendricks and Tipton of my situation, and expect to hear from them in a few days. I am now about 120 miles from Washington, and expected to have reached the city in 24 hours. January 30th, I am recovering very fast. The pains in the back of my shoulders are abating every day, and I have just put on my coat for the first time and find I can now wear it without much pain. I've just received a letter from Mr. Hendricks advising me to come to the city as soon as I recover. He intimates an opinion that the affair will ultimately terminate in my favor, but thinks my presence in the city will help. I think, according to my present feelings, that by Monday or Tuesday I shall be able to travel slowly in a sleigh, and that the snow in the mountains is now highly favorable to make that mode of traveling. Affectionately, Jesse L. Holman.
More than 2 weeks after his expected arrival, Judge Holman finally makes it to Washington and meets President Jackson. During this conversation, we learned that some of Holman's opponents, including Indiana Congressman Ratliff Boone, had accused him of being an abolitionist. While Judge Holman had emancipated his wife's slaves, during one of his earliest cases on the federal bench, he returned a slave to Kentucky. During his meeting with Jackson, he hurriedly reassures the president that he is not, in fact, an abolitionist. This seemingly calms the waters, as Jackson indicates his intent to send Holman's name to the Senate for its vote on his appointment.
Washington City, February 10th, 1836. My dear Alan, I am here and nearly well. All that remains of my disaster in the mountains is a sore head. My operations thus far have been to soothe Boone and Mccarty as far as possible. Our delegation is in a sad condition, at open war with each other, and this is the sole cause of the difficulty in my case. Neither Boone nor Mccarty appear to think that they will succeed. They seem to give up the contest as hopeless, but still keep the matter undecided. I have just parted with Boone on rather better terms than I had anticipated. If no change is produced in his mind by Davis and Hannigan, I think the matter will be favorably disposed of. Boone is the principal barrier now in the way, as I am told that the president wishes to have his opposition quieted down before he makes the appointment. I am already convinced that my coming all this way had good effort. My intention to visit the president tomorrow and also to go to the Capitol. I have already seen the president. I was accompanied and introduced by General Carr, who stands somewhat neutral in this business, though rather inclined to my favor of the appointment. The president received me very cordially. I was fortunate enough to find him alone. He conversed freely on a great variety of subjects, talked for some time on the subject of my appointment, and the opposition that was got up against me. Seemed to be apprised that the opposition was not so much against me, but as against my friends. He mentioned the charge of abolition, which Hannigan and others had stated and which I had answered in several letters which I had shown to him. I satisfied him completely on that subject, and especially by repeating my decision in the first Negro case I acted on a few days after I received my commission, and which I gave a certificate of removal to the slave to Kentucky. I stated the principles upon which I decided. It gave him entire satisfaction, and Carr remarked afterwards that the general was particularly pleased with my decision. He spoke of the appointment as if he intended to give it in my name, but said there was no need to be in haste about it, and he wanted to have Boone quieted as much as possible, as Boone was an old friend of his. I know not for how long I may have to stay. Jesse L. Holman.
Judge Holman eventually returns home to Indiana to wait out the remainder of the nomination process. President Jackson submits his name to the Senate on March 21st, and finally, in a letter dated March 29, 1836, Senator Hendricks writes Holman to inform him that the Senate has unanimously confirmed his appointment. The $1,000 salary of a federal judge was now Holman's for life, which would only stretch for another 6 years until March of 1842.
Just over 20 years later, and during the years of the American Civil War, Judge David McDonald was elevated to the bench in Indiana, succeeding Albert Smith White. Judge McDonald was born in Kentucky in 1803, but moved to Indiana at the age of 14. After laboring on his family farm, he spent several years working as a school teacher. In 1829, McDonald left the field of education to study law. He opened a small practice in 1830. McDonald served a term in the Indiana State Legislature from 1833 to 1834. His year in the legislature soured him on politics, which may explain some of the harsh criticisms of politicians found in his journal. After serving in the state legislature, he wrote, "It was time very uselessly spent. Besides, I ran a risk of contracting vicious habits. Debauchery of every kind prevailed among members." McDonald was elected as a judge of the 10th Indiana Circuit Court in 1838 and served in that role until 1852. He settled in Bloomington, Indiana in 1841 and began offering an annual 3-month law course at Indiana University. He served as a professor of law until 1853 when he moved to Indianapolis to open a private law practice. After 2 failed attempts to secure the federal judgeship in 1862 and 1864, McDonald was appointed a district judge for the United States District Court for the District of Indiana in December 1864. He served in this capacity until his death on August the 25th of 1869. Judge McDonald was a prolific diarist during his time on the bench, and today we will hear excerpts discussing the everyday activities of a 19th century judge. We also hear his reactions and private thoughts about Civil War era cases of notoriety. In the first entry, Judge McDonald reacts to the news of the appointment of Albert Smith White as the next federal judge in Indiana, a position he coveted.
Thursday, January 14, 1864. Just as I expected, Albert S. White. Tempora o mores. This is the work of those 3 men, Lincoln, Lane, and Usher. First, an honest man. Second, a shallow ingrate. Third, a coward and a knave. It seems hard that we can no more have a judge before whom legal learning and decent behavior are of any avail. White I have known for 31 years. He was much of a lawyer. More than 20 years devoted himself to politics and railroads. Latter much more the honorable of the two. Suddenly becomes our legal oracle.
The honest man to whom Judge McDonald refers is the President of the United States, Abraham Lincoln. Lane, the shallow ingrate, refers to Senator Henry Smith Lane, a United States Senator from Indiana. Usher, the coward and knave, is Secretary of the Interior John Palmer Usher, who had operated a law practice in Indiana in the 1840s and 1850s before accepting a political appointment in Washington, D.C. The judgeship of Albert Smith White would prove to be short-lived. Judge White suffered poor health almost from the day of appointment and was never able to preside over a term of court during the 8 months he was in office.
Monday, September 5 to Saturday, September 10. Learning at 9 o'clock this morning that Judge White is dead, determined to try to get his place, judgeship for the U.S. District Court for this state. At noon, I started for Washington. Got there on Wednesday. Lincoln, papers and claims before him. For 2 or 3 days, came home, arriving safely Sunday morning at 10 o'clock and finding all well. Of course, I cannot know, but I think I shall get this judgeship in a month or two. Let's see how Lincoln can refuse it.
Feeling optimistic, McDonald returns home to Indiana, where his confidence is soon bolstered by the intervention of 2 Supreme Court justices.
Saturday, September 24. My office all day. Judgeship. Here from Judge Davis, I learned that he and Judge Noah H. Swain wanted to have me appointed. I think I shall fail. It's all public sentiment.
McDonald was nominated by President Lincoln on December 12, 1864, and confirmed and commissioned the next day. In his next diary entry, Judge McDonald reflects on his change in status and the accoutrements available to him in his new office. The building to which he refers is the Federal Courthouse and Post Office building built in 1860. It was located on the southeast corner of Market and Pennsylvania Streets, where the BMO Harris Bank building now stands.
Thursday, December 15. Today with me begins a new era. Again to practice law. Warm congratulations flow on me from all quarters. States. Something nice here. And to make fires, nice furniture, elegant stationery, all free of expense to me. All this for life. Long wish by me. More than I hoped. It is like some of the fond creations in the Arabian Nights entertainment. I must see that I perform my official duties diligently, wisely, and faithfully. No man receive injustice at my hand.
The district court judge, McDonald, was also responsible for presiding over cases filed in the Federal Circuit Court. During McDonald's day, district courts handled minor federal cases where punishment did not exceed $100 fines or prison sentences of 6 months. Circuit courts heard more serious cases and appeals from district courts. There was no separate circuit judge assigned to the District of Indiana, so cases heard in the circuit court were presided over by a 2-judge panel consisting of Judge McDonald and Justice David Davis of the United States Supreme Court. Justice Davis visited Indiana annually as part of his circuit riding duties. In the following entry, Justice Davis has not yet arrived.
Tuesday, December 20. U.S. Circuit Court begins here today. I alone presiding. Still done. At p.m. I charge the grand jury. Saturday, December 31. In court all this time. Had a few criminal cases. for 10 years for robbing, for 5 years for passing counterfeit greenbacks.
The case of John Tucker, to which Judge McDonald refers, was one of great notoriety in the state. Mr. Tucker, who had been employed by the Postal Service in Vincennes for 16 years, was arrested on charges of stealing the mail. 12 empty locked mail bags were found hidden in his room, along with stolen goods, including letters, photographs, socks, jewelry, and false teeth. 1864 ends, and in the next entry, Judge McDonald reflects upon the business of appointing clerks.
Tuesday, January 3, 1865. Whole day on the trial of Fisher and did not end it. Daily beset by applications for clerkships, which were soon to become vacant. Yet, I body anything.
In Judge McDonald's day, district and circuit courts convened twice annually for a spring and fall term. When not in session, federal judges were free to pursue other interests. By the end of January, Judge McDonald has completed his fall term and is ready to adjourn court until spring.
Friday, January 27th. Today, our U.S. Circuit now free till May. Condition in which I have not found myself for many years.
During the Civil War, President Lincoln declared martial law to deal with Union dissenters. The administration suspended habeas corpus and initiated the use of military commissions to try civilian cases related to the war. Lambden P. Milligan, Stephen Horsey, William A. Bowles, and Andrew Humphreys were tried by a military commission on October 21, 1864, for charges of conspiracy against the United States government, offering aid and comfort to the Confederates, and inciting rebellion. Milligan, Bowles, and Horsey were found guilty and sentenced to hang. The men filed suit in federal court, claiming that, as civilians, they should never have been brought to trial before a military tribunal.
Tuesday, May 9. Morning, Judge David Davis arrived and joined me in holding court. Today, it is said that the authorities have fixed on Friday the 19th instant for hanging Bowles, Milligan, and Horsey, the Sons of Liberty, tried last fall. Sorry to hear it. Not that they are not traitors, but that there is too much doubt of their having been convicted by a court of competent jurisdiction. Davis has the same fears I have on this topic. We will try to induce the President to delay the execution till the Supreme Court shall pass. But our attempt will probably be unavailing, perhaps be much blamed.
On May the 10th, 1865, Milligan's legal counsel filed a petition in the Circuit Court of the United States District Court for the District of Indiana for a writ of habeas corpus, which called for a justification of Milligan's arrest. Judge McDonald and Justice Davis, sitting for the Circuit Court, agreed to disagree on their rulings. A split decision by the Circuit Court required that the case be taken up by the United States Supreme Court.
Thursday, May 11. We held court all day today. Application of Dr. Bowles was made for a writ of habeas corpus to be delivered from military custody under sentence of death. Certificate of division of opinion, it was sent to the Supreme Court of the United States. Judge Davis and I united in a strong letter to the President, praying him to delay the execution till the Supreme Court should decide the case. Hope he may do it. We are aware that this course may bring on us much popular abuse. So well persuaded are we that the execution of Bowles, Milligan, and Horsey would be impolite, illegal, that we cheerfully take the risk of the popular clamor.
Ex parte Milligan was argued before the United States Supreme Court on March the 5th of 1866. On April 3rd, the court issued its landmark decision, ruling that the application of military tribunals to citizens when civilian courts were available was unconstitutional. Milligan and his co-defendants were released from prison and allowed to return home. Ex parte Milligan became one of the most well-known Supreme Court cases during the Civil War years, addressing the limit on presidential powers. On the heels of the Milligan case came the trial of several conspirators for the murder of a draft officer. Judge McDonald reflects on these proceedings.
23rd. Today, we impaneled a jury to try Scott for being one of the conspirators who, in opposing the draft last year, murdered Captain Mccarty in Daviess County. Today, May 24. Morning, Scott made an affidavit to continue his cause for absent witnesses. He made the case over till Friday and sent attachments for his witnesses. Meantime, other of the conspirators charged with the murder of Mccarty appeared in open court and pleaded guilty. May 27th. Morning, we entered on the trial of George Y. Scott. Murder in Daviess County of Captain Mccarty on the 3rd of last October. Only a part of the evidence for the U.S. What we heard makes a case of awful murder. Proves Scott guilty beyond question. Trial was adjourned till Monday. May 29. Whole day on the trial of Scott. U.S. evidence was closed this evening. The case was made than which a stronger could hardly be imagined. Doubtful whether any evidence or argument will be offered in defense. May 30. Jury found Scott guilty of murder. 1. He entered on the trial of George W. Hedrick. The case does not look so strong as that against Scott. The President has commuted the punishment of Bowles and Milligan to the penitentiary for life. Saturday, June 3rd. This day, the jury found Hedrick guilty of murder. 3 persons already found guilty of the murder of Captain Eli Mccarty. Others are yet to be tried.
The murder of Captain Mccarty would go down in history as one of the most gruesome examples of tension at home between Union loyalists and Southern sympathizers. Captain Mccarty, enlisted in the Union Army at the outset of the Civil War, was wounded in the Battle of Perrysville, Kentucky, and sent home to recover. Once home, it became apparent that his wounds would prevent him from returning to active duty, and he was reassigned as a draft officer to the United States Army in Daviess County. There were many Southern sympathizers living in the Hoosier State, and a number of men in Daviess County were incredibly hostile towards the draft. They threatened Captain Mccarty, stating that they would take action if he tried to draft them. On the night of October the 31st, 1864, Captain Mccarty, armed with a fresh list of recruits, headed out to notify the men on his list. Mccarty was ambushed by a group of young men. The killing shot was fired by John McAvoy, but 4 other individuals were ultimately convicted of conspiracy to commit murder. Few other conspirators fled the state and were never apprehended. After being arrested, McAvoy pled guilty, while George Scott, George Hedrick, William Whiteside, and Dan Scales all faced trial and were eventually convicted and sentenced by the circuit court. In the next passage, we hear about the difficulty McDonald faced in sentencing the perpetrators.
Sunday, June 5 to Saturday, June 11. Solid week I spent. Monday, Whiteside and Scales were put on trial for the murder of Mccarty. On Tuesday, 5 of these murders now stand convicted in our court. I would at once There is, however, one legal point on which Davis is not all of the Supreme Court judges on that. Until November. To do the week, I held court alone.
McDonald's journals don't expand upon the legal point that drew Justice Davis's concern. However, the other Supreme Court justices must have shared his concerns, for when sentencing eventually took place, the conspirators received a mere 6-year sentence each, a decision that was widely ridiculed by many Hoosiers. The spring term is now over, and Judge McDonald reflects on his summer plans.
Saturday, June 17th, closed court today. I am put in November. I have had since 8. I had contemplated starting tomorrow to the judicial congregation calls, but this quarter's salary has not yet arrived, and I can't go without it. So I am in abeyance.
Judge McDonald's salary must have arrived shortly thereafter because, by the following Tuesday, he is on his way to Niagara Falls.
Tuesday, July 11th. On my way to Niagara Falls, I found myself in the morning at Crestline, Ohio, where I took breakfast, then pursued my way to Cleveland, where I arrived about 10 a.m. Here, I waited till 4 p.m. for a boat. I went on board of the fine Propeller Arctics, bound for Buffalo, New York, a distance of about 190 miles. On this boat, I found Judges Wilson McCandless and son and daughter, and Judge H.H. Levitt, milady, all bound for the Falls. Fine. We have a delightful sail. Wednesday, July 12th. Today, our judicial convocation assembled in the ballroom of the Cataract House. 11 judges were present. Consultation chiefly concerned salaries and the creation of an intermediate court of errors, so as to relieve the Supreme judges of errors. We agreed on a plan to be placed in the hands of our friends in Congress. Only 2 days, it ended.
Upon returning home to Indiana, McDonald joins forces with Albert Gallatin Porter, an Indianapolis attorney and former representative to Congress, and Charles A. Ray, an Indiana Supreme Court justice, to open a law school.
Tuesday, July 19th, Porter and Charles A. Ray agreed to hold a law school in Western next winter. I must go to work preparing. More leisure now till the 1st of April. Take this labor, not because I love it, but all I can to pay my debts.
It's October, and the fall term has begun.
Thursday, Bad case today. Older boy in jail, feeling out of post office. It appears to me that I can consist.
December arrives, and McDonald reflects on his efforts to open a law school.
Monday, December 4th. This is the day on which our law school was to begin. 3 students appeared. Friday, December 8th. I have organized a private law class. I'm teaching it daily. Court this afternoon and tried and decided an action of ejectment. 11. I'm now fairly embarked in a private law school. Attending were too few to make it a department in the Northwestern Christian University. abandoned that idea. I've turned them into a private class and teach them 2 hours a day in my law chambers at $40 per session of 4 months.
It's Christmas Day, and Judge McDonald still toils away at the work of a federal judge.
Ended thus. Breakfast. And got the depositions in the case of the collision of the steamboats Morning Star and Crescent City near Evansville, and annotated 182 pages of them. About 8 p.m.
Collision of the Morning Star and Crescent City steamboats, which took up so much of Judge McDonald's time on Christmas Day, resulted in significant property damage. The owner of the Crescent City sued the owners of the Morning Star for damages, charging negligence. The owners of the Morning Star rebutted this claim, leaving Judge McDonald to sort out the mess. Both boats had set off from Evansville on the morning of the crash. The Crescent City, a towboat hauling hay and coal, stopped a few miles outside of Evansville and prepared to dock at Dixon's Bend due to a patch of heavy fog. While waiting for clearance to dock, the Morning Star, a passenger boat, overtook the Crescent City and crashed into it. Neither boat claimed to have seen the other until the crash. Neither side had blown their fog whistle, as per protocol, and the Morning Star failed to supply adequate lookouts. Judge McDonald eventually decided in favor of the Crescent City, determining that lack of adequate lookouts, combined with reckless speeding by the Morning Star, were the most likely culprits of the crash. The Morning Star had admitted to overtaking the Crescent City at a whopping speed of 12 miles per hour. It's now 1866, and Judge McDonald is ready for a break.
Saturday, March 31. Day my law school ends. Grateful relief to me. 4 months, I have every day except Sunday.
Judge McDonald's break is short-lived, and by May, he is back on the bench.
Friday, May 25. Saturday, May 26. Serious case of Roberts v. Holman. A Yankee rogue. Gave judgment for the rebel for over $7,000. Day June 1, June 2. Spent these days in court. Criminal cases, mostly about passing counterfeit money. Stretches to penitentiary nearly every day. Day June 4, day June 7. Spent these days in court trying to 7th, spent in hearing Joseph E. McDonald, Henry Burnett, Judge Bartlett for the plaintiff, and George E. Pugh and John A. Hendricks for the defendants. It is an injunction case against the Indiana and Cincinnati Railroad Company.
Judge McDonald's spring term ends in early July, and none too soon, for he has taken ill.
Thursday, picture in my court state. Very warm, and I am very poorly. I learned about my in my study, revising my law. I completed to teach. My health will hardly support it. Drives the wolf.
McDonald's diary entries continue in much the same vein until his death in 1869. Many of his entries in the last 2 years of his life reflect on his poor health, which at times made it impossible for him to take the bench or hold his law school. He died in August 1869. In reading the letters of Judge Holman and the journal entries of Judge McDonald, we get a sense for the characters of these men and the workings of the federal courts during that time. Both judges were responsible for presiding over district and circuit court proceedings. For cases of original jurisdiction, this might have made little difference, but imagine appealing a case heard in a district court, only to find that the same judge who heard your original case would be one of a panel of 2 judges ruling on your appeal. That would soon change. In 1869, Congress assigned a separate circuit judge to hear circuit cases. In 1891, Congress established a separate United States Court of Appeals, but circuit courts remained courts of original jurisdiction over some cases. Circuit courts were abolished in 1911. Another big difference to the operations of the district court was the move from terms of court to a district court that operates year-round. In Holman and McDonald's day, court was held twice a year during spring and fall terms. When a term of court ended, judges were free to conduct personal business until the next term began. We see references to this pleasure in Judge McDonald's journal. Most federal judges in the 1800s did, in fact, have other income-generating businesses that they conducted in addition to holding court. Judge Holman was a gentleman farmer in Vincennes. Judge McDonald operated his law school. An appointment to the federal bench before 1869 came with no financial protections. From the time that the federal courts were established in 1789 until the passage of the Judiciary Act of 1869, there were only 3 ways to leave the federal bench: removal from office, resignation, or death. None of them entitled the judge or his family to further financial benefits, and no provisions had been put in place for retirement or disability. The Judiciary Act of 1869 offered the first provision for retirement for federal judges who had served at least 10 years. There were still no provisions for disability or survivor benefits. Today, being a federal judge is a full-time career with protections for disability, survivor benefits, and retirement options. With court open year-round, a judge's docket never clears. Here in the Southern District of Indiana, our judges have a packed calendar. On average, a district judge in the Southern District of Indiana has about 1,000 new filings and 2,300 pending matters on their docket at any given time, which is a caseload that neither Judge Holman nor Judge McDonald could likely have imagined. And with that, we close today's program. If you're interested in learning more about the early court, please consider reading Federal Justice in Indiana, The History of the United States District Court for the Southern District of Indiana, written by George W. Geib and Donald B. Kite, Sr. I'd like to thank you on behalf of the Court Historical Society for your participation. We hope that you enjoyed this fall's lineup of CLE presentations, and we look forward to having you join us again in 2022. And finally, I'd like to bring out our actors to take a bow. Jay Hempel portraying Judge Holman and Craig Riesener portraying Judge McDonald. Both actors are from the Indiana Historical Society's Museum Theater Department.